Be seated. We're ready to proceed on the case of MOREL versus Senior First Incorporated and the Unemployment Appeals Commission. Mr. Trammell, ready?
Good morning. May it please the court, my name's Talbot Trammell. I'm appearing on behalf of the claimant, appellant Gina MOREL. Gina worked for Seniors First Corporation for 14 years, and her last evaluation report, 6 months before she was discharged, was outstanding. It was the best report that she could have gotten at that time. On June 16th, she was having lunch with a friend off duty and off of the premises, and the friend was not an employee of the company that she worked for. And in that conversation, Gina was really mad because she'd gotten a call that morning that her employer was trying to get her to pay more money for her telephone calls, etc., than she should have. And in the conversation, she told her friend not to answer the phone if the employer called, and also told her friend that she planned to say that some of the personal calls were work-related. And
in other words, they wanted to pay her, she had an obligation to pay the minutes over a certain amount, is that right? In other words, they had a company phone.
Yes, sir.
The company paid for a certain number of minutes. If you went over, they said, well,
yes,
the personal calls you got to pay for.
That's true.
But she was mad at that. She did, I mean, that was the first time it happened to her, I take it. Right?
First time it had happened to her in 14 years, as I understand. I don't know.
Mr. Trammell, the one thing I couldn't tell from the record exactly, and kind of in your brief you say something about, did she pay the money before she knew there was a recording of the conversation, or was it after?
The record does not show.
Okay.
It does not show when she was told about that conversation.
Okay. I got
and
it.
Well, the record, her testimony does say, I tried to make amends after they got this recording. I tried to make amends. I told them I was sorry, and I paid the whole bill. That would seem to indicate that the sequence was they got the recording, she found out about it, then she paid the bill.
It does.
Right?
It does, Your Honor. that shows it. And
But she never did implement her plan, did she?
No, sir. She never did anything to carry out that plan. And after they told her about it, she wrote them a letter of apology. And then they accepted her check in full payment of the entire bill, by the way, including the entire overages. And then 5 days after that, they fired her. And when they fired her, it's really...
Well, is it your position that whatever plan, that she could come up with any plan she wanted of dishonesty, and if she didn't go forward with it, they couldn't terminate?
It's my position that if her plan was off-duty, because there's a line of off-duty cases that have established definitely that she can be, if misconduct occurs off-duty and does not harm the employer's interest,
so if what they had overheard,
entitled to benefits.
Okay, so if what they had overheard her say was, I'm going to break into the business tonight and steal all the money, they couldn't fire her for that because they'd have to wait and let her break into the building and steal the money before they could fire her for cause? Is that your position?
According to, they could fire her. They could fire her, of course.
Would that be for
they
cause?
can fire her any time they want to.
Would that be for cause? Would that be?
Well, it wouldn't be misconduct connected with work. If she makes the statement and then never does it, they can fire her if they hear about it. They have the right to do that. There's no doubt about it. But then, according to these cases, and I've got 5 of them, if there's misconduct and there's no, the misconduct does not harm the employer, then the employer has to pay benefits. She's entitled to compensation.
Was there argument that there was harm to the company in the sense of they're a public nonprofit, they rely on donations, their image out in the community is important, and therefore if somebody's out there saying they're going to rip them off or steal money from them, that could harm the company?
They didn't say that was harm, but they made that argument that that's what she said. However, this was the most secret conversation one could have, and the public didn't know anything about it. If they had told people around about it, it'd make a big difference. But it was not broadcasted around. It was a secret. Nobody would have known it except her and her friend if she hadn't done it. I mean, that really shows no harm to their business, and they hadn't. And the referee didn't find that there was any harm to her business. There's no finding of fact involved in this that we have to deal with. It's undisputed that it was an ultimate off-duty act of misconduct. All she did was say the words, and they didn't suffer any harm from it, from what she said. As she said those words, it didn't harm them at all. Nobody knew about it except them, and so but no one did know about it.
I guess I'm a little troubled by the notion that planning harm against your employer is not misconduct under the statute. In other words, the example that Judge Palmer used, if you plan to embezzle or steal or rob the company that you work for and went to somebody and said, I need you to do this in order to aid my plan, and the employer finds out about it, that really isn't misconduct in your view?
Well, in this case, in the Porth case, and in all these, in the Porth case, a person had planned to go into business in conflict with their employer and violate their duty of fiduciary duty of loyalty to the employer.
And he did it on company time, didn't he? I mean, the planning of that was on company time, as I recall, in that case?
In that case, it was.
I mean, that was the misconduct. It was doing it on company time, I think, wasn't it?
I see. Yeah, it was. And then but he didn't do it.
Yeah. And
he didn't do it. And so they said since there's no harm resulting from it, then he wouldn't be stopped to have his. However, in that case, they went on and sent it back for further proceedings. And when they tried to get employees to come work for his new business, they said that would be misconduct connected with work, and that he couldn't recover on that basis. According to the cases that I've cited, and other cases deal with pretty extreme situations, but to answer your question, Judge Lawson, if he said that he was, if they knew that he was actually going to do something, and like I say, they could fire him, but according to those other cases, the misconduct isn't connected with work unless they suffer some harm from it.
Now, the Porth case you refer to, that's an Iowa case, right?
Yes, sir, it is.
What do you think is the most closely analogous case that's a controlling case for us?
I feel that the three cases which say that the Balder case and the Nelson case and I think it's...
Well, the Balder case is an Arkansas case, so that's not controlling on us.
It is an Arkansas case.
The Nelson case is a Washington case. That's not controlling on us.
Well, that's true, but
my question was, what do you think is the most analogous case, Florida case that you have?
In Florida, I don't think there are. I think this is a case of first impression in Florida for an off-duty conduct case. And Florida hasn't established any law pertaining to off-duty conduct cases. And since it is a case of first impression, I went outside of the state and found these other cases that say that you have to prove several things for an off-duty case. I'd like to, they had mentioned in their, the Wells case as additional authority. They had submitted that case. And I'd just like to point out that that case is not an off-duty case, and the law is different as to off-duty cases and the regular cases. And in that case, Wells went to the controller of the company and said that he intended to go into business as a subcontractor, another business, and according to the referee's finding, the referee told him, don't do that or you'll get fired. And so he did it. Now, in this case, GINA MOREL hadn't done anything as a result of what she said she would do. And it's different. If you would, one way to point out the difference between the Wells case and the MOREL case, this one, is to assume that Wells had had a conversation with a friend and told him, I'm going into business and I'm going to compete with my employer, and I'm going to do what I can to get business and so on. And according to the law of these cases which I've cited, if he didn't, if he stopped there and didn't go into business, but in the Wells case he did go into business. He went into business in that case. So that's one difference. But if he didn't go into business, then he wouldn't be liable. But it was a different situation because it was an off-duty case instead of the Wells case not being an off-duty case.
Isn't one of our standards here to determine whether there was evidence that this was an act of dishonesty? Because the case law is that you can be terminated for cause for an act of dishonesty, correct?
All of those cases deal with dishonesty on the premises or on duty. All cases cited that I found, except maybe one where the employer did suffer damage as a result of the dishonesty, where it was an off-duty thing.
Is it your position that this conduct by your client was not an act of dishonesty, or that it was an act of dishonesty but it's not terminable because it was done off premises?
It was, it actually, the first time I thought about it, I thought, well, she made these statements and this was what she said, and that's not an act. But then when I thought about it, the referee said that she devised a plan to cheat, to lie about her phone calls. And so the devising of a plan seems to me to be an act, and it was dishonest. So I would say that that you would say it was a dishonest act.
If she'd had this same conversation with a co-employee sitting at her desk, would it be your position that she could be terminated for cause?
She can, I don't know. I don't know. But I know since she didn't have it at her desk, according to the law, that she couldn't be, according to these cases that I've cited. I feel it's a different standard for off-duty conduct because of the fact that it's not within the scope of the employment, and it's harder to prove a case if it is off-duty.
So if she devises the plan with a co-employee, but she does it at her house after hours, that's not actionable?
I would say that could be, because then she's involving the business to a greater extent.
So the geography is not the controlling factor, where she is at the time that she has the conversation. You don't think that's the controlling factor?
No, but I do think that, together with the fact the harming the business. It could be argued that if she did that with a co-employee, she was harming the business, but she didn't. We were talking about what if she did, but if she didn't, then...
Why is the unexecuted plan any more harmful to the business if she does it with a co-employee or with an outsider?
Well, I guess if it's not. I don't guess it is any more harmful to the business.
And so you would say the conversation in her house with a co-employee also wouldn't be a cause for termination then? Is that your position?
Well, I don't know. Maybe I would. Well,
You have 4 minutes if you want to reserve any time.
all right, I'll reserve it. Thank you.
Good morning. May it please the Court. John Hamilton on behalf of Seniors First, Inc., one of the appellees in this case. I think Ms. Morel's argument is fatally flawed in at least two respects. One, I don't think it can be reconciled with the plain and rather straightforward language of the governing statutes. And two, I think an acceptance of that argument would represent really, really bad law and horrible policy. And I think the argument ultimately is that it's not misconduct connected with work or dishonesty connected with work, the language of the statute. For an employee to plan, announce, and make no mistake about it, begin to carry out a scheme to steal from her employer, but be prevented from doing so only because the employer discovers the plan and terminates the employment before the plan can be fully realized. To me, to say that that is not misconduct, or that it is not dishonesty, or that it is not connected with work, distorts and tortures the language of the statute beyond all recognition. And they haven't cited any case from any jurisdiction in which a planned but not totally completed crime by an employee against his or her employer.
Let me ask you this, Mr. Hamilton.
Sure.
There are some cases out there that seem to say if it's a long-term employee, and we would say she's
I'll concede that.
And that it's an item of poor judgment. In other words, they do something stupid. They seem to say, well, that doesn't defeat their claim. You can fire them, but it doesn't defeat their claim for unemployment. Why isn't this a poor judgment case?
Because the law distinguishes between poor judgment or negligence or bad idea and out dishonesty.
Okay.
And out dishonesty, even a single instance of that, is under the case law a sufficient act of misconduct to justify or to constitute a basis for denial of benefits. And the statute itself singles out dishonesty. 443-101 subsection 9 by itself singles out dishonesty. And that's separate from the 443-101-1A misconduct connected with work. So, I mean, the legislature has said dishonesty alone will do that. And they haven't cited any case that really involves a situation like this where an employee plans and starts to carry out an act of dishonesty or a criminal act against an employer and was terminated as a consequence of that, and nonetheless has been deemed to not have committed misconduct.
You said that she began to carry out her plan, or are you just talking about the conversation with the...
Let me explain that, because the representation has been made that all she did was talk. She didn't do anything in furtherance of it. And to be sure, she didn't complete her plan. But also to be sure, she did start the efforts towards the completion of the plan. And what I mean by that is she told the evidence and the testimony was that she told her friend not to answer the phone, and that if she was contacted, to say that her conversations were work-related. That's on page 77 of the transcript, or 77 of the record. And that is the beginning of the plan that she announced that she formulated and she intended to carry out.
I take it her friend was one of the numbers on
The testimony was that there were 4 to 6 calls to that friend on the telephone bill in question. So, yes, she didn't just hypothetically announce something and not do anything in furtherance of this scheme. She started it. She began it. She was caught before she could carry it out. So it's just not supportable by reference to the record to say that she didn't begin this effort. She was caught. She was terminated before she concluded. That was a criminal act. It was something that was misconduct. It was dishonesty, and it was connected with work. Under the statute, that's all you have to have. And I said this would be bad policy. And I think I could make that point. And I don't mean to be melodramatic on this, but I think you can make that point if you simply take the facts of this case and replace the property crime of theft that we have here and replace it with something like a crime of violence in the workplace. And
Kill somebody or something?
Something like that. And I don't think we want to do anything that wants to provide employers with a disincentive to take the appropriate remedial measures when they hear of something of that nature. Of course that's a misconduct associated or connected with work, and of course they have the appropriate responsibility to themselves, to the other workers in the workplace, to take the appropriate action to keep that from happening, to protect themselves and to protect others. Now let me talk about the arguments, and they were really the arguments in the reply brief, because the argument, it seemed to me, to change somewhat from the initial brief to the reply brief. In the initial brief, it was more, this was not an act of misconduct. In the reply brief, it sort of morphed, to my mind, into a new argument that there has to be some additional showing, that there has to be a showing that there was harm to the employer before it can be deemed misconduct connected with work. And they characterized this as a question of first impression under Florida law, and they referred to a standard that was adopted in cases in Arkansas and South Dakota and, I'm drawing a blank, Washington for that. And I suggest that that argument, I could make an argument that an argument raised for the first time in a reply brief shouldn't be considered, but I'll go beyond that. Several things about that. One, to me, that adds an element to our statutes that's simply not there. The plain language of the statutes does not say misconduct connected with work and taking place off duty, or excuse me, I misspoke, and taking place while on duty, or misconduct connected with work and causing harm to the employer. That's language that they are seeking to engraft upon the statute that we simply don't have. Now, whether they wanted to do that in Arkansas or Washington or South Dakota, that's up to them. We don't have that in Florida. That's not in our statutes. That's not something that I suggest the courts of this state ought to be doing. It ought to apply the statutes as they are written. I do also have sort of a question, and this is just something that occurs to me. I'm not sure whether we really have the off-duty facts here. I mean, this is a woman who was off at lunch, and I'm not sure that when I go off to lunch as a salaried employee, that I'm really off-duty within the meeting.
You're still billing your client.
I think that's right. Well, I'm not billing my client, no. Unless I'm talking over lunch about the case. But yeah, I'm not sure that's really off-duty within the meaning of these cases. I mean, she testified that she was on call at all times anyway.
Do you think it makes a difference?
I don't think it really does. Because, I mean, those cases were designed to determine whether the off-duty activity was related to work anyway. And this quite clearly was related to work. And if you look at those cases, I mean, the one that I think was emphasized, maybe not the most, but certainly prominently, was the Arkansas case, the Balder Electric case. I mean, that was a domestic violence conviction that resulted in the employee's termination. But the very end of the case, the very last page of the case, the Arkansas, I guess it's Arkansas Supreme Court, made a point of saying that that case did not involve any intention by the employee to cause any harm to his employer. implying certainly to me that if that case had involved an intention by the employee to cause harm to his employer, the result would have been different. Well, this case did involve that. Our case does involve that. And if you go through the other cases they've cited, they don't involve situations in which the employee won because of a finding or a conclusion of no intention to cause harm to an employer. They are decided on other grounds altogether, albeit in situations in which they've articulated the standard that they are asking this court to adopt. But the standard itself, I think, even if adopted by this court, and even if the court decides it wants to read into the statutes words that aren't there, I don't think it hurts us. And you know, what they're saying is that this court should judicially amend the statutes to require that harm be suffered by an employer before misconduct connected with work can be found. I think we've got that here. I mean, the idea that an uncompleted criminal act is harm is not new or remarkable or startling under the law. We have a whole body of law in conspiracy. We have a whole body of law of attempted criminal acts, attempted murder and other such crimes that can result in adverse consequences, criminal liability, imprisonment. That is harm. That is harm under the law. And being subject to an attempted criminal act is harm by an employer. And I think if you want to say that an employer has to suffer harm before we have misconduct connected with work, we've got that here. This employer was on the verge of being subjected to the criminal act of having money taken from it to which it was rightfully entitled by this employee. So if you want to adopt that standard that they're advocating, fine, but it's satisfied here.
Let me ask you something. You got a cross appeal, correct?
I have a cross appeal. I don't know that it's necessary. I'm sorry.
I was curious. Did y'all have the phone bill? Couldn't you tell from the phone bill if her phone went off at that time and called? Wouldn't that reflect in the phone bill?
You're talking about Ms. Schuff-Dowd's phone bill.
Yeah, when her phone went off, evidently, and called her boss and intercepted the conversation. It would seem that the call would be on the phone bill.
It certainly would seem that, and I wish that was in evidence.
So
wasn't in evidence.
Yeah.
And
okay.
So I
but the hearing officer, referee, I guess, he made a finding that her phone did do that. Right?
The hearing officer,
the commission said.
Yeah, and I suggest that the commission could not properly have rejected that finding because there was testimony that the call was made, that the
no other explanation.
There's not another explanation for it other than this bizarre wiretap theory that she came up with.
But it still would go to voicemail.
It can't go to voicemail, and both witnesses on behalf of the employer testified that it did end up on the voicemail. She admitted herself that it ended up on the voicemail. At one point, she said it was accidentally on the voicemail. I think everybody who's had a cell phone has experienced the phenomenon of either sending or receiving a voicemail or a telephone call by mistake. She testified that her phone was on. Well, she testified that her phone was off. But she also testified that it rang constantly, that she was on call 24/7. Reconcile those two. It seems to me that's up to the finder of fact. In this case, the appeals referee, who could have found and did in fact find that the call was made by accident. That's up to the finder of fact. The Unemployment Appeals Commission, I don't think, had the ability properly under the law to reject that finding of fact, given that there was evidence to support it. And to the extent, if any, that it's necessary for this court to ascertain whether that decision by the UAC was proper, I suggest that the UAC did err in rejecting that finding of fact. Before I sit down, let me say a little bit about the standard review. Under the case law, the decision as to whether something is misconduct connected with work has been deemed to be a question of law. But the case law also says that unlike most questions of law, that one is not subjected to de novo review. The case law says that is subjected instead to the clearly erroneous standard of review. Standards of review matter, and that distinction makes a difference here. So I suggest to the court that even if you disagree with the conclusion of the UAC as to whether this was or was not misconduct connected with work within the meaning of the statute, I don't think you can get anywhere close to the conclusion that this was clearly erroneous. I don't think it was erroneous at all, but I suggest it's not clearly so. So if it's not clearly erroneous, they haven't satisfied their burden of proof in this appeal, and the decision by any standard should be affirmed. I thank the court for its time.
Okay, you have about 6 minutes if there is any rebuttal on the cross-appeal issue that you...
Thank you, Your Honor.
Hello, I'd like to thank you for giving us this chance to orally argue the case, and respectfully pray that you will reverse the UAC and award benefits to GINA MOREL. Thank you.
Okay, thank you very much. Okay.